Today, we will discuss the legal pitfalls of inadequate partnership agreements in real estate transactions. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Partnership agreements or LLC agreements in real estate transactions are not merely a formality. They are the firm foundation upon which successful collaborations are built. A robust partnership agreement should clearly define each party's roles, responsibilities, and contributions, thereby minimizing potential future disputes. Without a comprehensive agreement, even the most straightforward real estate deal can quickly become a complex legal quagmire. Many individuals entering into real estate transactions underestimate the complexity and potential for conflict inherent in these joint ventures. A well-drafted partnership or LLC agreement should anticipate areas of potential disagreement and address them proactively. The absence of such a document leaves room for disputes over profit sharing, decision-making authority, and exit strategies, which can be extremely costly and time-consuming to resolve, especially when emotions are already running high. Engaging an experienced real estate attorney and CPA can help ensure that the agreement covers all necessary aspects and complies with applicable law. One of the most common pitfalls of inadequate agreements in this context is the lack of clarity regarding exactly how profits and losses are to be allocated amongst the members. When expectations are not explicitly documented, costly disagreements can arise, leading to strained relationships and potential litigation. A detailed agreement, therefore, should specify the method of profit and loss allocations, considering the members' initial contributions, ongoing financial obligations, the desired share of returns, and the tax considerations of each member. Additionally, tax implications, as I just said, play a significant role in how profits and losses should and can be allocated. Different allocation methods can have varying tax consequences for the members involved. A well-structured partnership or LLC agreement designed and implemented with the aid of a knowledgeable attorney and CPA working in unison will address these tax considerations proactively, thereby helping to ensure compliance with the Internal Revenue Code and applicable Treasury regulations, thereby optimizing each partner's tax position. Another critical area where inadequate agreements can falter is in the delineation of decision-making authority. Without clear guidelines on who holds the authority to make decisions or how those decisions are to be made and implemented, partnerships can become paralyzed by indecision or, conversely, plagued by unilateral actions that may not reflect the collective interest. Real estate ventures often involve significant ongoing financial commitments and strategic decisions, such as property acquisitions, financing arrangements, and development plans. A comprehensive partnership or LLC agreement should outline a decision-making process that includes voting rights, quorum requirements, and procedures for resolving inevitable deadlocks. This clarity helps prevent misunderstandings and further helps to ensure that all members are aligned in their strategic objectives and participation. The absence of these clearly defined roles and responsibilities is another common issue in partnership agreements. Vague or undefined rules or over-reliance on boilerplate agreements from past deals can lead to overlapping duties, missed opportunities, or conversely, unaddressed responsibilities. Each partner's contributions, whether monetary, managerial, sweat equity, or otherwise, should be explicitly stated in the agreement to ensure accountability and operational efficiency. In real estate deals, roles can range from property management and financial oversight to tenant relations, marketing, and maintenance responsibilities. The agreement should outline each member's anticipated contributions of time and money and the consequences of failing to meet these obligations. This specificity protects the membership from being mired in disputes over perceived or actual inequities in workload or contributions. Planning for the termination of the venture or the exit of a partner or member is a crucial component of a well-crafted agreement. Failing to establish clear exit strategies and options can leave the venture vulnerable to disputes and financial instability. A comprehensive agreement should include buy-sell provisions, push-pull provisions, and drag-along rights, just to name a few, which outline the terms and conditions under which a partner or member may exit or be bought out. These provisions should address scenarios such as voluntary withdrawal, involuntary removal, death, or incapacity of a member. By defining the process and valuation methods for a partner's interest at the outset, these so-called buy-sell provisions protect the remaining members and ensure the continuity of the venture. Needless to say, consulting with an experienced attorney and CPA during the drafting process, and certainly before any letters of intent or term sheets have been signed, can help tailor these provisions to the specific needs and objectives of the stakeholders. Partnership or LLC agreements must also address tax compliance and reporting obligations, as I alluded earlier. Real estate transactions have unique tax implications, including the treatment of income, depreciation, and capital gains, not to mention passive loss limitation rules. Inadequate agreements may fail to specify the responsibilities of each member regarding tax filings and compliance, thereby potentially leading to penalties and interest. A well-drafted agreement will assign tax-related responsibilities, outline procedures for preparing and filing tax returns, and establish clear protocols for handling inquiries from the Federal Internal Revenue Service or state taxing authorities. By addressing these considerations, the agreement helps ensure that all members are fully informed of their obligations and prepared to meet them. There should be no surprises. Engaging an attorney during the drafting process, as I said a few moments ago, can provide valuable insights and creative alternatives into the tax implications of the operations of the venture. Entering into a real estate transaction without conducting thorough legal and financial due diligence is itself a significant risk. An inadequate partnership or LLC agreement often stems from a lack of understanding of the venture's legal and financial landscape, sometimes as a result of the do-it-yourself approach, which can, of course, be extremely costly. Comprehensive due diligence allows partners to identify potential risks and liabilities, ensuring that these are addressed at the outset. Due diligence involves reviewing title reports, zoning laws, environmental assessments, and financial statements, just to name a few considerations. It also includes evaluating the entity structure, funding sources, and potential liabilities. An experienced attorney and CPA can guide members through this process, ensuring that the agreement accurately reflects the findings and provides sufficient protection against unforeseen challenges. These agreements are complex, bespoke legal documents that require careful crafting and consideration and expertise to draft effectively. Inadequate agreements can lead to significant legal and financial detriment, undermining the success of any real estate venture. By engaging an experienced professional earlier in the process, Partners and members can ensure that their agreement is comprehensive, compliant, and tailored to their specific needs and objectives, as well as the needs and objectives of the geographic locale. The pitfalls of inadequate agreements highlight the importance of professional guidance in navigating the intricacies of real estate transactions. From defining roles and responsibilities to addressing tax implications and exit strategies proactively, a well drafted agreement is indispensable for protecting the interests of all stakeholders and maximizing the likelihood of long term success. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.